Asylum status is a form of humanitarian protection offered by the United States. Eligibility of asylum application. Every year, thousands of people come to the United States from different regions of the world seeking protection from persecution. According to the US law, one can apply for asylum if they have suffered persecution or fear that they will suffer persecution due to race, religion, nationality, membership in a particular social group, political opinion. Procedure of asylum application. You can file an asylum application if you are physically present in the United States and you are not a US citizen. There are two types of asylum application, affirmative and defensive. A non-citizen who is not currently in removal proceedings may apply for affirmative asylum through the USCIS. On the other hand, a person who is in removal proceedings may apply for asylum defensively by filing the application with an immigration court. From November 2022, affirmative applicants can file their asylum applications online. Asylum applicants can legally work in the U.S. while their application for asylum is still pending. Asylum applicants now can apply for employment authorization document online. Wherever the asylum seeker stays in the USA, 𝗦𝘂 provides fast and accurate services with proper care. 𝗦𝘂, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.
Hello, everyone. Thank you for joining this show. Today, we have a special show. Today, we will talk about EB-5. And today, we have a guest speaker. His name is Benjamin Hu. He has experience in EB-5 application for more than 11 years. Also, he worked in China about U.S. immigration law. His office was right next to U.S. consulate in China. So I would not wait anymore. I would like to invite Benjamin Hu, my good friend and fellow expert about EB-3. Hi, Benjamin. How are you?
Hi, Raju. Doing very well. Thank you. And it's a delight to be on your show today.
Thank you very much. So before we take any question from our prospective clients, our audience, or from me, would you please give a like a brief presentation about EB-5, and before that, would you please introduce yourself?
Absolutely, yes. As Raju already did a fine service in introducing me, my name is Benjamin Hu. I got my citizenship the easy way. I was born onto a U.S. hospital bed and I began breathing. And I understand that there are many very skilled, expert people of great merit who are trying to get to America and take up their green cards and get citizenship here as well. And so I've made it my life goal, much as Raju has his, to try to get these people to come to America, contribute to our universities, to our economy, and to our employment. So that then leads us into, I suppose, a seamless segue. What is EB-5? Now, many people may be familiar with EB-1, EB-2, EB-3. The EB in these numbers all means employment-based. And the grades 1, 2, and 3 show the different levels of merit and specializations and expertise for the employment base. So for EB-1, you might see extraordinary abilities, Einstein visa, as they're called, or outstanding researchers or CEOs and multinational managers. So that really is like top of the field, top of their careers. EB-2 are people with advanced degree holders and whose jobs in the US would require advanced degrees. And EB-3 are skilled workers and other workers, people who require at least a bachelor's, or some seasonal workers and unskilled workers. So as you can see, there's these different gradations. I'm here to talk about EB-5 because it's kind of an odd duck in this entire strata. If we can see the talking points, please. EB-5, it is technically employment-based. It is technically employment-based, but it is not so much you becoming an employee so much as you coming to America and investing in America and making a sizable contribution to the American economy to create employees. And so I'll just go through this. It's a potential solution, and right now it's time sensitive too, because there's special treatment if you are already in the US or if you can get to the US on a valid status like student or H-1B. And if you can consider an EB-5 immigration, for a limited time, there is no waiting list for any country in EB-5 going forwards. And so I'll talk a little bit more about that. But the exciting news about that is that if you do qualify for EB-5, you could actually file for adjustment of status at the same time. And that locks in your eligibility to remain in the USA while the USCIS is processing your case. So without further ado, EB-5 investment immigration. Last year, we had a very dramatic bill called RIA, the Reform and Integrity Act, and that tidied up quite a few definitions. It changed quite a few small details about EB-5, and most importantly, it created a few new categories for EB-5 investments that have top priority. These ones do not have any long waiting lists yet. Some may appear. But we'll go through them, and we'll go through more options for investors, especially for those who are currently in the USA. So EB-5 is an unusual employment-based category. Anybody who's been considering perhaps working for a US company or perhaps starting your own US company for EB-1 or EB-2 or 3, you might be aware that the US company is the one who controls the attorney. It is the US company who files the petition before USCIS. Not so for EB-5. Here, it is you, the foreign investor, who self-petitions. So you control the attorney, you control the I-526 or I-526E petition before the USCIS. The petition cannot be stopped without your permission. So this is resoundingly flexible. It's resoundingly favorable. There have been rare but regrettable situations where a person has gone through the EB-2 process, and then when it's already mature, the employer has perhaps a hiring freeze or they have adverse economic conditions, and they come back and they say, we're terribly sorry, we have to cut you from our workforce and we can no longer proceed with the EB-2 or EB-3. Not so with the EB-5. You are the one who makes the investment. You're the one creating the jobs for American economy. And so you are the one who hires a lawyer and controls the process. You cannot be cleaven aside from your own process. So that's a big win if you consider EB-5. The process is also lengthy, as EB-2 and EB-3 might be. It requires the initial form I-526 or E, depending on what flavor of EB-5 investment you want to do. You can file the adjustment of status if there's no waiting list. Currently, as we mentioned, there is no waiting list, so more on that later. A few years afterwards, after Immigration Service has reviewed your promise to create 10 jobs, and they think that your 526 or 526E is credible, they'll approve it. What does that get you? Well, that gets you the ability to adjust status if you're in the US, or to show up and apply for consular processing at a US embassy or consulate. And that will get you an immigrant visa that gives you 2 years of conditional green card, conditional lawful permanent residency. And now the 2 years is not, it is not 2 years and then you're out, but it is 2 years to say you may come to America and oversee your investment, work, study, or not study, as you please. But at the end of those 2 years, the USCIS expects you to then file the I-829 removal of conditions. And that is a chance for the USCIS to say, well then, Mr. Investor or Ms. Investor, have you fulfilled your promise to really create 10 full-time jobs in the US economy? So it's kind of like a two-step process. Number one is, here is my plan. Here is my promise to create this amount of jobs with this amount of money. And then at the 829 stage, they say, very good, please prove this to us. Please give us the documentation to show that your plan has created 10 jobs. And if they then approve the 829, you then get a permanent green card. And as all permanent green cards, this is the document card itself is valid for 10 years and it can be renewed indefinitely. And there are no further limitations. You may stay here. You may eventually convert to citizenship if such is your wish. So then what are the EB-5 investment requirements? Now, I'll start off by saying that unlike EB-1 and EB-2 and EB-3, there is actually surprisingly few biographic requirements about you, the investor. You don't have to prove a PhD or master's or even bachelor's. You don't have to prove any academic achievements. You don't have to prove that you're the top percent in your field, in your country, or in your community. You do not even need to prove, strictly speaking, that you speak English. There's no language requirement for EB-5. Instead, it is purely focused on your investment of a minimum amount of money and the promise, the credible promise of job creation. And so we have these details here that you must have a minimum amount of investment, which is generally seen as 1.05 million, 1,050,000 after 2022. Before that, it was 1 million flat. That has now been closed off, and you now need that extra 50,000 on top. If you invest in certain areas, then you may reduce this amount to 800,000. And this $800,000 amount may be more within the reach of CEOs, private business entrepreneurs, or even people who have successfully speculated in real property. We do see a pattern with countries such as mainland China, where the government has recently relaxed rules on private property ownership. And so then suddenly a few apartments that you own, the price skyrockets, and that is a respected and valid way of proving lawful source. But you do have to show documentation. The US government does expect to see documentation that the funds are lawfully sourced. And then where does this money go? It will go into a business inside US territory, a for-profit business, so it cannot be a charity. Certainly cannot be you establishing your own household and saying, I'm going to hire 10 staff. That simply won't do. But it is something that will create jobs and engage in economic activity. Now, the two flavors of EB-5 are quite important. It is either now called a standalone, where you have the plan and you are managing it, or into a regional center. And the regional center is a convenient process that delegates a lot of the drudgery of the job creation record and a lot of the job hiring. And it also allows for pooling of EB-5. So say if there's 10 friends who want to get together and invest their 1.05 million or 800,000, they have to do the regional center model. They cannot do a pooled standalone. That is categorically disallowed. So the use, what does the American society get out of this? Well, they get 10 full-time jobs for qualified employees for at least 2 years. You are expected to create the 10 jobs, and they must last for at least 2 years. Otherwise, they're considered temporary jobs. And you also need to have a credible business plan to do this. Now, if you do a standalone investment, which is our next slide, thank you so much. If you do a standalone investment, that is the romantic and historically very common notion of an immigrant with a briefcase and a plan in their head and business plans in their briefcase coming to America and with the money lawfully sourced, and they're saying, I'm going to open up a new hotel, or I'm running a successful factory for parts in my home country, and I want to start a franchise in America, or I want to start a branch in America that distributes these or produces these and ships them back. And I need factory workers. I need hotel workers. So that is standalone. And that is your own for-profit business plan inside the US. You would then be responsible for deciding whether or not you are in the targeted employment area. That's if you want the 800,000. If you want the 1.05 million, the normal level, this is fine anywhere. But if you want the discount, then you'll need to handle the TEA calculations, which can be quite finicky. And simply put, TEA is a certain definition of rural area or a certain definition of high unemployment area. And the responsibility for making sure that you're doing business there and creating jobs there then devolves to you. So you would have to make sure that you're looking at the relevant census tracts. Your lawyer can help you, your business plan drafter can help you, but it falls on your shoulders. And if there's unfortunately a mistake or a misunderstanding, then the immigration service will come calling you or emailing you and saying, hello, please explain this discrepancy to us. So the responsibility goes to you. And then also the job creation, managing the business to create those 10 full-time jobs, that would also fall upon your shoulders. Not a problem for many people if they're already in America, if they already have that briefcase of plans and briefcase of money. But for some people, they prefer a more hands-off approach. And that is where the EB-5 regional center investment category comes in. Now, a regional center is kind of a definition of art. Immigration Service says that if a company wants to define themselves as a regional center, there is a certain form they can file, and there's a certain 2 or 3 years long process that they go through. And then US immigration then says, very well, we've reviewed your documents. We have given you this label stamp of regional center. So that 2 or 3 year period of time, that's fairly significant. It is theoretically possible for a person to create their own regional center, but it's probably not feasible, especially if you're in America and if you want to file as soon as possible. The good news is that there are hundreds. At the last count, I think there's more than 700 regional centers already certified in America that have already done business for years under the previous EB-5 label. And these regional centers are usually very happy to take on new affiliations. So if you have a plan and if you've got several buddies who want to do EB-5 pooled investment with you, then you can contact a regional center. Your lawyer can contact a regional center and sign up under them. Oftentimes there'll be a licensing fee. More than that, some regional centers also run their own off-the-shelf pick and choose projects. So if you want to delegate much of the drudgery and headache and logistics of the area selection and the job creation, you can actually find a regional center who has their own projects that may have some or all of their funding for the project for development coming from EB-5. And so that is very much like a subscription. Usually there's not much flexibility in how it's run. The project already knows how it wants to build this new shopping mall or build this mixed office and commercial and residential building. But it will be some sort of very large project. It will often be with people who have a lot of experience in developing, and so you can review their track record. So that's added consolation, added reassurance. And the regional center then takes care of things like handling TEAs. They can have their economist experts and their financial experts review the census tracts and say, yes, this is rural, or yes, this is a high unemployment census tract. And they can also manage the business of hiring people, getting boots on the ground and hard hats in the construction area, or even white-collar workers behind office desks to fulfill that quota of 10 full-time jobs of 2 years duration for each investor. One other small benefit for EB-5 regional centers is that they can use what's called econometrics to calculate job creation. And that's a special advantage that the USCIS, the Immigration Service, has granted to regional centers, that you can have money in, however many tens or hundreds of millions come in, and then money out, how much they spend, and they can then calculate that in the abstract to say that in this area, this amount of money spent, therefore means this number of direct jobs, this number of indirect jobs, and so forth. Why is that significant? Well, that's significant because in a standalone investment, you can't really do that. In a standalone investment, you are required to be one man or one woman and one plan and creation of 10 documented workers. So you need to really have their names, their social security numbers, their W-2s, and so on and so forth. So that's kind of a difference between the two. Number one, the standalone is great if you have your own plan and how you want to run things and you're confident in your ability to do so. And number two is more, say you're here on an F1 student visa or you're here doing H-1B, you have some other status that is taking up your time and you're focusing on that, but you would like to reserve open the future prospect of getting a green card a few years from now, and your money, you have your lawfully sourced income and you want to make your money work for you, but you don't want to get your hands into the details of running an everyday service. So here's a timeline, or here's a process rather, of the EB-5 process. You would need to prove that you've got lawfully sourced funds, and so your lawyer would work with you probably as step one to do this, because you don't want to get further on down the timeline and realize, oh crumbs, I've got this one transaction that seems insufficiently documented. So then you want to make sure that your lawfully sourced funds are proven. Then you put the funds into the business, whether it's your own mom and pop shop or your own hotel, or it's into a regional center funded project. Then you file your I-526 if you're running your own business, or you file the I-526E if you're with a regional center. The differences are not terribly large. Then you can adjust status if you are inside the US on a valid non-immigrant status and if there's no waiting list for your nation. This is a novelty. This is probably the most important takeaway from my speech today. If there's anything else that you remember, please remember this. EB-5 has been around since 1990. So that's a good 33 years. And all since the beginning, EB-5 did not allow you to file your 526 and the adjustment of status. They said, no, you must wait until your 526 has been approved. And then if you're in the USA, you may file 485. Well, the US government has given us a treat in 2022. And they have said that if you're filing an EB-5 going forwards and there's no waiting list for your country of birth, you may also file a 485 for adjustment of status. And the rule is universally that a properly filed adjustment of status allows you to remain lawfully in the United States, and you may also file for a re-entry permit or advanced parole, 131, and you may also file for an employment authorization document, 765. Well, suddenly this opens up a very broad frontier, as you can imagine, for foreigners in America looking to make a new life in America and looking to contribute to American workforce and looking to contribute to the American economy, and also perhaps wanting to be able to go back home and do business plans there or meet with their family. It really opens up a much greater reward incentive for somebody here who's already a student or already a worker on a non-immigrant status to say, well, great, if I do EB-5 in the future, I will get a benefit, but also I can remain here and oversee my investment. So this is a golden opportunity. And I'll talk a little bit more about the waiting list a little later. But right now, the fact is before us today that if you filed an I-526 or an I-526E, then you can also file the adjustment of status. And that pending adjustment of status lets you eventually leave and re-enter the US validly. And it allows you to work or not work in the US as you please. But that's a rather lengthy editorial aside. Back to this timeline. Once the I-526 has been approved, if the investor is outside of the US, then they can start the DS-260 consular processing. And that's the process that I happily oversaw when I was in Guangzhou, China for 3 years in my office overlooking the US consulate. At that time, it was the global ground center, you could say, for EB-5 investor immigrant visas, because the majority of the applicants were all from China. Consular processing will get you an immigrant visa stamped in your passport, or if you're already in the US and you have not already done so, then the I-485 adjustment status can be filed at that time. Then that gives you the 2-year conditional lawful permanent residency, or the conditional green card. You may come to America. You will do all the things that green card holders do in America. You'll file taxes to the US government. You'll be allowed to work, be allowed to study, be allowed to live here and leave and re-enter. And then starting from 21 months after you've got that status, which is to say 3 months before the 2-year anniversary, you may and should file the I-829 removal of conditions. And this is the final step. And the 829 removal of conditions shows to the US government, Uncle Sam, I have promised you that I'll create 10 jobs. Here is my documentation to show that I created 10 jobs. Please remove the conditions and approve my green card process. These processes do take time. The I-526 in its heyday, and it's been a little skewed now because of COVID, but the I-526 took 2 years or more at that time, which is why at this time it's important, if you're considering an I-526 and if you can get to America on a non-immigrant visa, it's a good idea to consider the AOS as well. So 2 years of I-526 or more, and then you get your 2 years of conditional green card, and that means 2 more years, so 4 years. And during that time, you may live and reside in the US, and then you file the I-829 removal conditions. And that is in front of us right now. We're seeing that is actually taking 4 years. So 2 plus 2, 4 plus another 4 years. So that's currently 8 years. That having been said, the Biden administration did state in 2021 that they're adding an extra $400 million budget to the USCIS. And they did also say aspirationally, they're trying to get processing times across the board, the median processing time across the board, to about 6 months or so. And I'm sure Raju has also seen this. And in many other categories, we are also seeing speeding up of these processes. So there is hope. We are cautiously optimistic that these times will reduce. But it is a long-term end game with a current golden window that if you file the 526 or E at the same time as the AOS when you're in the US, that actually locks you in and lets you stay here while you wait. Possible developments and synergies. Oops, here we go. For possible developments and synergies, as I've already mentioned, there's currently no waiting list. Waiting lists may appear for high demand nations. Historically, we have seen waiting lists show up for China, mainland China, that is to say, not Taiwan, not Hong Kong. And we have also seen waiting lists in the past for India and Vietnam, and there was a threatened waiting list for South Korea, which previously did not actually materialize. But based on current visa usages, a South Korean waiting list could potentially appear. What happens when a waiting list appears? Well, anybody who's in the system will then kind of take a ticket in line based on the day that they filed, not the date they're approved. So the earlier you file, the earlier you are on the waiting list. But another fairly important development is that once a waiting list appears for a nation, then anybody who applies in future in that nation can no longer file for the AOS. So if you're here on an F1 or if you're here on an H1B and you're trying to file a 526 when a waiting list has already appeared, you cannot file an AOS. And so there is no immediate relief of saying, well, I've got my placeholder waiting in line for me, I can stay in the US. You would need to prolong your F1, prolong your H1B, or prolong your other non-immigrant status to allow you to lawfully stay in the US separate from the AOS, because you could not file the AOS until the waiting list has been satisfied. Another possible development, many lawmakers are talking about what's called a recapture of the EB-5 quota. We are pushing that quite hard with many lobbying groups and congressional information groups. What is this? Since 1990 until the present day, many years of EB-5 went by without anywhere near the quota of 10,000 visas being used up. And so those quotas were just lost into the void. And there's currently a movement to say to Congress, look, we're not asking you to create more visas. We're asking you just to recapture all of those visas from 1990 till 2014, 2015 that were wasted, add them to the current quota and allow more people to do EB-5 quickly. Another issue, EB-5 filing is an immigrant petition. So anybody who's here on an F1, you might be aware that there is a certain sensitivity about showing immigrant intent. So just keep that in mind, that EB-5 does show immigrant intent. It could potentially have some effect on non-immigrant statuses. Your immigration attorney or a skilled immigration attorney can work with you on that with timing and also with other aspects of that to help defray any possible effects. And the big one, for those of you who are from certain countries that have signed the treaty investor bilateral treaty with the USA, the E2 status is called the treaty investor status. It's a non-immigrant status, but it's very similar to the EB-5. It is a temporary status. It has to be renewed more or less every year or so. And if you fail to renew it, then it expires, but it's fairly fast. So you can think of E2 as being a quick but temporary solution for somebody who wants to invest, and an EB-5 as being slow but permanent. And if you are from an E2 treaty investor country, you could consider one transaction that satisfies both if your attorney and your financial planners can help you plan the details of such an investment. Unfortunately, the two most waitlisted countries, India and China, do not have E2 treaty investments, but Republic of China in Taiwan does. I believe so too does Pakistan and many members of the EU and many members of South America and Central America. So it's certainly worth looking into it. And final crossover, the EB-1C and L1A could potentially be a crossover with EB-5. The EB-1C and L1A are basically for CEOs, board members, directors, general managers, very high-level corporate people who are functioning in that role in a non-US company outside of the US. These people often also have very high compensation, and so they're able to potentially do an $800,000 or $1.05 million investment, and quite a few of them do EB-5. And so the L1A, EB-1C, those could be a way to get you here quickly, and then the EB-5 could be a long-term way to get you a green card. So that is by necessity, somewhat whirlwind quick tour of the EB-5 category. Raju, I don't know if you have anything to to add or any questions to ask, or if the viewership has any questions, I'm very happy to share with you my knowledge.
Thank you very much, Benjamin. Yes, I have some questions, and audience, if you have any question, you can comment in our Facebook or any of the links. So we will see it and we'll show it on the screen, and Benjamin will answer your question. So Benjamin, my first question is, there are some countries in the world who do not allow their citizens to transmit a lot of money out of their country. Like, for example, Bangladesh, they only allow like $10,000 in one transaction. So can you tell us a little bit about like how people from those countries, how they manage to bring money to America?
Certainly. So the first issue many people ask is, America requires lawful source of funds, that word lawful source of funds. And then they say, well, my country has a certain regulation. They want to control currency exchanges, and they've made it unlawful to engage in certain things or to circumvent certain things. So a very reasonable question. If I'm, perhaps finding ways to get around this artificial limitation of freedom of my money, what does the U.S. government think about that? And in previous opinions, the U.S. government has taken the stance that, the U.S., as you know, is a jurisdiction that allows people to freely exchange and move their money. So as far as the U.S. government goes, that is not illegal under U.S. laws. And they have taken the position that if the sole deviation or circumvention is to get around another country's artificial currency control, such as Bangladesh, to a certain degree, such as India, and to a large degree in People's Republic of China, that action by itself is not unlawful under American laws. Perhaps in the same way as certain political speech in certain countries might not be permitted, political speech is permitted in the U.S. And so the U.S. would not view speaking in certain political speech in certain jurisdictions to be unlawful under U.S. laws, even if it is unlawful over there, just as a kind of example. As far as actual solutions go, that does depend very much on each jurisdiction. I speak from experience in People's Republic of China, for example, where for a long time there was a $50,000 per capita per annum cap on how much there could be converted. And so oftentimes you would have somebody in China who would then collect together, I suppose now it's 16 friends or 18 or 20 friends, and then each friend then takes their Chinese currency from the investor and then actually performs lawful currency exchanges for the US dollar amount, and then remits the US dollar amount into account or accounts that are also held by the EB-5 investor. So that is a fairly common occurrence. Recall, however, that the US government does require lawful source. And so that means anybody whose hand touches the funds, they also have to demonstrate that while the funds were in their hands, it was not used for anything untoward. So sometimes if the family member or the friend holds on to the money for just one day, then there's bank accounts to show that they held on to it for one day and the money merely remained in their bank account and was not used for anything that was unlawful. So that is one example, the large number of friends. There are other solutions that EB-5 investors have done, especially the demographic who engages in EB-5 often are also very well connected globally. So just to use the example of Chinese business entrepreneurs and CEOs, they may also have friends who are in Hong Kong. And Hong Kong is a free currency exchange jurisdiction. And so it is quite common also for a Chinese person to say, I have this money and I'm now going to give it to my Hong Kong friend. And my Hong Kong friend accepts this money and they then acquire the US dollar currency, and then they give it into my account. And this account now is owned by me. So I have the US lawfully sourced income, and I then make the EB-5 investment. USCIS has become also more desirous. They've become more taking a closer look at this particular transaction. So the friend does need to be willing to disclose like identification documents and also currency tracking documents, which accounts it went through, what it did in those accounts, and so forth. My favorite example is a Chinese investor who had an American friend who had a factory in America and sold products in America. So just through his own revenues, this friend happened to have this significant amount of free cash lying around. And so he just gave this free cash to the Chinese investor because he needed Chinese money in order to pay workers in China, because he also had a Chinese operation. So this was a beautiful arrangement for both of them. The money went to the Chinese investor, and he made the EB-5 investment. And then the US government came back and said, we want to see everything about the U.S. factory and about the U.S. business, and knock on wood, we were lucky that the U.S. Business owner was like, everything I do is entirely above board, and we're very happy to disclose everything. Whatever Uncle Sam wants to see, we'll let them see. Here are our sales up before that time. As you can see, it was 900,000. So we were able to produce 500,000 and give it to our good friend in China, and they gave us this money. So it's kind of, sometimes it's an evolving landscape, but yes, people who have the connections and who have the lawfully sourced income and the lawful means to find other solutions can do so. Sometimes it requires some financial creativity, and sometimes it requires some lawful thinking outside the box. But it is very frequently a question that has solutions that the U.S. government accepts.
Yeah, thank you. My next question is, somebody needs to invest 1,050,000. So do you need to invest the entire money before you submit the application, the form 526E, or you can invest, like, let's say 500,000, submit the form and keep investing more and more, and then before you get the approval, your 1,050,000 quota is filled up? What is the rule?
The actual rule is fairly flexible, but it is not backed up by a significant amount of rulings. So we are in a situation where the flexibility of the rule actually makes wise investors more willing to adopt a conservative approach. So if you file the I-526, that form is for your own mom and pop shop. And so sometimes the economic realities do mean that I cannot collect the 1.05 million, or I cannot collect the 800,000, and I have to do it piecemeal. That is allowed under the USCIS policy and regulations. They do not require you to have everything in the account before you invest. The vast majority of people who file the I-526E, I will say, which is the form that Raju mentions immediately, they do have to provide all the funds up front. Why? Because the I-526E is the regional center form rather than the mom and pop shop form that you file with your own plan. And regional centers are usually quite risk averse. They want to make things, the best possible outcome for their investors. And so they want to have as little ambiguity as possible. No, Uncle Sam, do not question this. The investor got all 800,000 and it's here right now. And then on day 2, they file the I-526E. So you cannot come back and raise this question of, did you file all of the funds necessary? The actual language, and this is all publicly available on the USCIS policy manual, is almost horrifyingly flexible. It even says that at the 829 stage, which is after your 526 has been approved and after you've gotten the 2-year green card, and when you're filing to get the 10-year green card, it even says that at that time, they contemplate the possibility that you might not have invested all your money, which to me is really pushing the envelope of economic viability. Because at that time, the 829, you're supposed to be trying to prove to Uncle Sam that you've already created the 10 jobs. So that really would be kind of close to the wind. If anybody has the courage, shall we say, to try to stretch that definition as flexibly as it will allow, I'd be very interested to see how that goes. But generally speaking, my philosophy would be to try as much as possible to get the money in before you file the 526. If you can't get the entire money in, especially if you're running your own hotel or your own business or your own development in the USA with the 526 standalone, that's okay. But as long as you do have to have a business plan that's credible and that lays out rigid milestones for the investment. And another key part too about the investment is that once it's placed into the business, there does need to be contractual controls to ensure that whoever's filing the EB-5 cannot just arbitrarily pull the money back out and pay for their lunch or pay for their rent. There do need to be very strict controls. And some of the earliest EB-5 court rules have been disqualifying businesses where somebody was treating the EB-5 standalone investment as their own personal piggy bank. So that's just something else to kind of keep in mind. It's more of a contractual issue, but the immigration lawyer who helps somebody with their standalone will also need to keep this in mind. So you'll want to have an immigration lawyer helping you with this. You won't want to do it alone, I would say.
And so it is also allowed to start your own apartment complex business under EB-5, right?
Yes, the EB-5 actually is very broad in what sort of business you may do. It has to be for profit, so you can't do a nonprofit, and it has to be somewhere in U.S. territory. So you could theoretically open up a business in Guam if you like to, or Puerto Rico, places that were not U.S. states, but nevertheless U.S. territory. An apartment housing complex would be acceptable, provided that it is a genuine development that is seeking commercial tenancy and so forth, and commercial residents to come in. But by commercial, I mean, for profit, not necessarily business. You could have private tenants. What is not allowed is, well, I want to build a really big mansion for myself and my family, and I'm going to hire 10 people to work for 2 years minimum to wait on me hand and foot. The USCIS policy manual expressly prohibits that sort of homestead or domicile type of job creation. But yes, it is theoretically possible if you're going to be the one to hire the developers and to build residential compounds. Yes, that is permissible. And in fact, many regional center projects are for very high occupancy, very large scale projects that are essentially like a scaled up version of an apartment block.
So my last question before we end, at least my question, that is, so let's say somebody invested 1,050,000, and let's say after like 4 or 5 years, at the end of the day, he did not get the green card for some reason. He can sell his investment and he can take the money back to his home country, right?
That's a good question. The U.S. Immigration Service is indifferent to what happens to the investment if the green card process is halted or denied. Right. So once you've decided, I don't want to do this anymore, and we've had clients who have done that. There was one client who got a job at a cross-border organization that triple taxed her, and if she got U.S. green card, she would then be quadruply taxed. And she said, "It's quite all right. I don't need this." At that point, the U.S. government the U.S. Immigration Service is completely agnostic and completely indifferent to what happens to your money. So you certainly could get your money back. That is a contractual question for you and the regional center, or you and whatever contract you drafted for your own standalone project. Yes, if we're talking about selling the investment, that itself is a little questionable. I mean, a lot of people hear that phrase and they think, well, I'm waiting in line. I'm position 1002 in the EB-5 queue. Can I sell this to another person who wants to take position 1002 in the EB-5 queue? And the answer is no. I mean, the Immigration Service will not sort of say, Joe Foreigner A was in this position and has given their interest to Joe Foreigner B, and they have the same. That is not something that the EB-5 regimen contemplates. But if you're talking about getting your money back, yes, that is possible. Again, it would be a contractual issue. And one of the issues, just a final reminder, this is an investment. Remember, this is an investment. EB-5 is always investment, and investment is defined as capital placed at risk with a chance of profit and the risk of loss. Risk of loss, that's key. So any EB-5 structure where the investor is actually loaning the money into the business is likely to encounter difficulties, or where the person has a guarantee or a warranty or a right of redemption. So if you're asking about, if we say I'm investing, but at the end of the day, there's some sort of guarantee I will get my 1.05 million or 800,000 back, be very careful about that. And anybody that uses the word guarantee, bond, surety, warranty, redemption, those are things to be, raise an eyebrow about that and look closer at the black print.
Thank you very much, Benjamin, for joining this show. I think we are hitting our upper ceiling of the time. I really appreciate your time. And dear audience who are watching the show right now or who will watch later in our YouTube, Facebook, and other media, you can directly reach out to Benjamin Hu. His name of the company, his email address, website, everything is shown on the screen. And also you can just Google him. He will be available. He will be able to answer all of your questions if you just email to him. Again, I thank you, Benjamin, for your time, and thank you everybody for this great time.
Asylum status is a form of humanitarian protection offered by the United States. Eligibility of asylum application. Every year, thousands of people come to the United States from different regions of the world seeking protection from persecution. According to the US law, one can apply for asylum if they have suffered persecution or fear that they will suffer persecution due to race, religion, nationality, membership in a particular social group, political opinion. Procedure of asylum application. You can file an asylum application if you are physically present in the United States and you are not a US citizen. There are two types of asylum application: affirmative and defensive. A non-citizen who is not currently in removal proceedings may apply for affirmative asylum through the USCIS. On the other hand, a person who is in removal proceedings may apply for asylum defensively by filing the application with an immigration court. From November 2022, affirmative applicants can file their asylum applications online. Asylum applicants can legally work in the U.S. while their application for asylum is still pending. Asylum applicants now can apply for employment authorization document online. Wherever the asylum seeker stays in the USA, Radulo provides fast and accurate services with proper care. Radulo, one of the top immigration law firms in the USA, is your trustful address for any assistance and advice regarding immigration to America. To know more, dial the number shown on your screen.